a gine cór an gedal sestó fircin fóilse roth éileag, agus ach go hóirithe na cóirtáirí spéisial tá go usna cuairsta dilithe éasúla thar lear agus áthas arm go bhfuil an seansa gan an ochchaid seo an fóilseúg seo agra agus muid I ciúra ochchaid sandasaach seo ciúra céad bhliain ach na gúta na bhreithúna snédig fé ceathair. May I say how welcome you all are to us in Uachtaráin, and how pleased to be an honour to have this opportunity of having a reception, which is part of the special occasion that constitutes the 100 years since the enactment of the Courts of Justice Act 1924. Chief Justice, you and all of those attending this centenary events are most welcome to Áras in Uachtaráin, and I have read with interest already the report of your comments earlier today on both not just the importance but the importance of the adequate provision for the future needs of the judicial system. And I've also read with interest your interview with the Legal Review at the University of Galway, which encouraged me to reflect myself on what I think of the 1924, which was a very, very significant, very interesting period in the history of my own family. May I particularly welcome too Siofra O'Leary, President of the European Court of Human Rights, who joined us today. Trís Liam Leis Gwingwach Banach there Saraba Fiontak Tavakta Shilaki. May I also offer a very warm welcome to the senior representatives, as I have said already in Irish, from the 11 countries who have travelled to Ireland this week to be part of the celebrations. We're adding this gathering to a number of centenaries that share a context. In recent years here at Áras in Uachtaráin, we've been marking a decade of centenaries, formative years. The proceedings of some of these are now available in two bound volumes, Mochnaf 1 and Mochnaf 2. But our exercise began, I think, with the 1913 Dublin lockout. It went through the War of Independence, a terrible civil war, and culminated in the events that led to the establishment of the Irish Free State. However, what happened in the years after 1922, which include the legislative changes of the Free State government in those early years, were formative actions that would have an enduring legacy, including, of course, what we're calling this evening the Courts of Justice Act 1924. In a letter to the Executive Council members of the Irish Free State in January 1923, President W.T. Cosgrave wrote, "There is nothing more prized among our newly won liberties than the liberty to construct a system of judiciary and an administration of law and justice according to the dictates of our own needs and after a pattern of our own designing." There was, however, a troubled, painful background for so many people in Ireland that serves as context to this view that he expressed. A particular challenge had arisen in relation to the division of domain lands. Approximately 1.34 million lands were left to be divided, and there were several views as to how Landtonga was to be satisfied. The 1923 Land Act had come after a number of earlier acts, which at the beginning in the 1880s, which had turned tenants into peasant proprietors. It had released a hunger for land. And after the 1923 Agricultural Act and the acceptance of the majority report of the 1924 Commission on Agriculture, the grazier-led cattle economy was privileged. This was interpreted widely as an abandonment of the aim, the land for the landless. Land agitation was widespread, and a special force was established to deal with it, the Special Infantry Corps. Those released, for example, such as my father, in late 1923 or in 1924 from incarceration as anti-treaty prisoners would regularly have their names given to the special anti-land agitation group. Many of those, including myself, my father, were forced to leave their native parishes, and a considerable number emigrated, as did agricultural labourers, as the acceptance of the majority view of the 1924 Act meant that tillage must now give way to cattle. A particular challenge arose, as I have said, in relation to the division of domain lands, and other scholars have pointed out it is not unrelated to the burning of the big houses, which in fact so as to ensure that the lands would be divided, and a great number of opportunities in relation to how such resources might have been used were of course contained in the Minority Report by Mr. Buckley and Tom Johnson. Within months of taking office, Cosgrave established a judiciary committee chaired by former Lord Chancellor, Lord Glenavy, appointed to advise the Cabinet of the Free State on the establishment of a new court system, one that would supersede the Dáil courts or Republican courts, the judicial branch of government of the Irish Republic, which had unilaterally declared independence in 1919 and which had been established by a decree of the first Dáil, the 29th of June 1920. The Dáil courts had been an important element of the Irish Republic's policy of undermining British rule in Ireland, establishing, as they did, a monopoly on the legitimate use of force, the seizing of power by the people, taking over the administration of law and order in their own communities, and turning their backs on the enforced British judicial system, made international laws, as Mary Kotsanouris has noted in her book Retreat from Revolution, the Dáil Courts 1920 to 24. Small tribunals adjudicated, and in which another one of my uncles served, in local disputes about land. The local volunteer companies abducted and punished thieves and petty criminals, directed public order at race meetings and fair days, and in some parts of the country burned down as had to existing courthouses. So it is a troubled, as I have said, and painful context to Mr. Cosgrave's statement. President Cosgrave's appointment of Glenavy as Judiciary Committee Chairman was an exercise in bridge building, I suppose. Lord Glenavy was an establishment figure under the old regime, a staunch unionist who had served as MP for various Dublin constituencies and a leading member of the Masonic Order. So it was perhaps surprising to some. On the other hand, he had accumulated considerable legal experience, having been successively Attorney General, Lord Chief Justice, and finally Lord Chancellor of Ireland, immediately before independence. He certainly found favour with the Free State government, which also appointed him to the Senate, of which he became first chairman. Incidentally, we can probably thank him, and you made reference, I think, to him, Chief Justice, earlier today. We can thank him or blame him, depending on your perspective, for having saved the traditional wig and gown worn by judges and barristers. Hugh Kennedy, then Attorney General and later Chief Justice, wanted to replace this garb with a new uniform, and by all accounts, a highly colourful one, modelled on what he believed Irish Brehon judges would have worn centuries earlier. Glenavy ridiculed this proposal, saying, "Remember, this is a thing that can be altered and re-altered by each successive Minister for Home Affairs. The present Minister for Home Affairs might prefer a kilt. His successor might be a sporting man, and he might prefer a jockey's costume. The next successor might have clerical tendencies, and he might prefer to see the judges robed in clerical costume. Where is this thing to end?" The Glenavy Committee produced a report in May 1923 with detailed recommendations for the establishment and operation of the District, Circuit, High and Supreme Courts. The Courts of Justice Bill 1923 was published in July, and after much debate, the Courts of Justice Act 1924 was signed into law and commenced in the summer of 1924. Today we mark this important milestone in Ireland's history. The Act is one of the most significant pieces of legislation passed in the Free State, establishing as it did the basic structure of our court system, which has endured for a century, with only the addition of the Court of Appeal in 2014 and the Special Criminal Court, the first of which was established in 1972 and the second in operation since 2016. And I do welcome with great indeed, as I have already said, with interest, the proposals as to what is needed in the future that the Chief Justice referred to in his speech to you all earlier today. The 1924 Act was wide-ranging, seeing district courts replacing the Court of Petty Sessions and the Justice of the Peace. The justices of the district court were professional judges and had jurisdiction over minor civil and criminal matters. The circuit court had jurisdiction in more serious civil and criminal matters. On the criminal side, the most serious offences, such as murder, were reserved to the High Court. Court of Criminal Appeal, to hear appeals from the circuit and High Courts, was also established. Provision was made for a further right of appeal to the Supreme Court on a point of law of exceptional public importance. The Supreme Court was created as the final court of appeal to be presided over by the Chief Justice. Prior to English rule, going back to Kennedy, Ireland had its own indigenous system of law dating back to Celtic times, which survived until the 17th century, when it was finally replaced by the English common law. This native system of law, to which I've referred already, known as the Brehon law, developed from customs which had been passed down orally from one generation to the next. Indeed, it was the 7th century before laws were written down for the first time. Brehon law was administered by Brehons, or Brehon, the successors to Celtic Druids, and while similar to judges, their rule was closer to that of arbitrators, tasked with preserving and interpreting the law, rather than expanding it. In many respects, Brehon law was enlightened and was an enlightened progressive by today's standards. It recognised divorce and equal rights between the genders and also showed concern for ecology. In criminal law, offences and penalties were defined in great detail. Restitution rather than punishment was prescribed for wrongdoing, this being a feature shared with many indigenous systems, including those which I know of in Africa, which have been widely studied, such as the Barotse, for example. Cases of homicide or bodily injury were punishable by means of the Eric fine, and the Eric fine was a form of tribute paid in reparation for murder or other major crimes, some of the exact amount determined by a scale. Capital punishment was not among the range of penalties available to the Brehons, and indeed the absence of either a court system or a police force suggests that the people had strong acceptance of this law. Seeking to expand its influence, English authorities sought to reassert the supremacy of their parliament and of English law over any Irish parliament or Irish legislation by enacting the Statutes of Kilkenny in 1366, written in a form of French and debated in English and Irish. This was followed by the enactment of two statutes at a parliament held in Drogheda in 1494, together known as Poynings Law, which provided that the King's Privy Council must give prior assent to the assembly and legislation of an Irish parliament, and that all laws passed in England applied in Ireland. By the 16th century, English law was, however, confined to an area known as the Pale, made up of Dublin and the East Coast, beyond which Brehon law continued to be applied. It was not until the reign of King Henry VIII, some decades later, that English law extended further when the king implemented a scheme of surrender and regrant of the land held by native noble families, which brought them within the feudal system of land tenure. English law gained a further and in many ways in historical terms, defining foothold following the defeat of Irish forces at Kinsale, which was followed by the flight of the Earls from Ulster in 1607, and the consequent plantation, which saw the land being granted to Scottish and English settlers. The flight of the Earls had an added significance in that it removed the Brehons' remaining source of patronage, and the end of the Brehon law's authority was signalled by the proclamation of King James I in 1603, which resulted in Ireland being subsequently divided into counties, a legacy of doubtful value, may I suggest, in administrative terms when it comes to local government, right up to the present, which is a personal presidential observation. English law was now sought to be administered throughout the country. The dominance of English law was consolidated I think by, of course, Oliver Cromwell's military campaign, brutal campaign of 1649 to 1652, as a result of which many more Irish landowners were forced from their holdings to resettle in Connacht. It was a forcible ejection, as such, for the purpose of satisfying inter alia the payment of wages to Cromwell's soldiers. Brutal repression of Catholics in the form of penal laws would later become a defining feature of the late 17th and into the 18th centuries, before a series of reforms were enacted, with calls for the repeal of the Act of Union in the 19th century gradually and continuously being amplified, with the eventual separation from the Union coming via the passing of the Irish Free State Constitution Act in 1922. The period of oppression, including exclusion on the basis of religion, proscription of the Irish language, its use being punishable even by children, in the bata, as it was well known. And while every country has its own court system, and I was a quick glossary of our own history of our own, some of which are, there's some of, when every country having its own system, some which are very different to the system we have in this country, but all at their best aspire to the same aim, that is, of ensuring that justice is achieved and that the outcome of the case is fair and reasonable. A fair and impartial judiciary and justice system is indeed accepted as the bedrock of any functioning democratic system, and Bunroch na Hare and the Constitution of Ireland has served us well over the past 87 years. While it did not provide the individual liberties and freedom that everyone desired, it gave us the freedom and the space to achieve them. And today's Constitution reflects how we have changed as a society and as a country. In the past, constitutions were, as Sartori among others might have put it, to provide certainty and, when necessary, cast a cold judgment on people's lives. Today, it recognizes both the uncertainty and the possibilities of the changes that may be experienced in all our lives, and has evolved to acknowledge the importance of respecting personal freedoms rather than of limiting them. One may well ask if there is any aspect of our republic more essential to its effectiveness and continuity than the independence of our nation's courts and their ability and capacity to uphold the rule of law. It is, after all, our judiciary that has an enormous responsibility in being part of a system that seeks to ensure not only that order is based on a legitimate and democratically sourced assent, but is maintained in our nation, and also that the struggles in which the citizens of our country engage with each other, whether over law, ideas, politics or social values, are resolved reasonably and fairly. And so I pay tribute to you all gathered here this evening for your commitment and your work in relation to all of these matters. And in particular, I must say as well, having welcomed all of our visitors from abroad. You're so maragurt me firkin folsharov. A special welcome to you. And I think you being here reminds us that the vindication of rights has required the transcendence of borders. The 1948 Universal Declaration of Human Rights affirms that recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. Thus, the development of a regional system of human rights protections operating across Europe, as expressed in the subsequent European Convention on Human Rights, has played a crucial role in the development and awareness of human rights in Europe. This convention has ensured that people have basic needs recognized and sought to be met, that vulnerable groups are protected, that people can confront societal corruption, that freedom of speech and expression are encouraged, that freedom to practice religion and to choose partners to love of one's own choice are safeguarded, that equal work opportunities are encouraged, that people have access to education and that the environment is protected, and that governments can be held accountable in that regard and others. Achievement of gender equality in terms of access to the highest positions in the administration of law is of such importance, and in Ireland progress has been made, and it is so welcome. I had a reception here called Women and the Law. I hosted it in Áras in Uachtaráin in November 2021. It recognised those first women called to the bar. And great strides have, I am pleased to say, been made in terms of gender balance amongst the legal profession today, with many women in recent years holding the highest positions in our courts and legal institutions. Great citizens such as Catherine McGuinness, Susan Denham, and Shifra O'Leary, whom we have the honour is with us this evening. At that reception, held in November 2021, as I said, I recall the first women called to the bar. On the 1st of November 1921, Frances Kyle and Avril Deverell are remembered appropriately as trailblazers, serving justice and making history. So let us recall too those who provided an alternative to the prevailing orthodoxy of those early years in the new stage. At times lonely figures such as Thomas Johnson, a prolific legislator and committed parliamentarian who advocated for a peaceful alternative to the bloody conflicts that gripped the decades of our nation. Again, it was he and Mr. Buckley, as I have said, who wrote what would have been an entirely different context for those statements with which I opened my remarks, the Minority Report of the Commission on Agriculture. As judges, you are the linchpins of the justice system, ensuring through your constitutional and judicial functions that the guiding principles of such hallowed documents as the Universal Declaration on Human Rights and the European Convention on Human Rights are upheld. More focal skirt to conclude. Law, I think we must always remind ourselves, can, and it is important to remember this, be emancipatory, but only when our system of law is fair, maintains accountability and works to protect all citizens, especially the most vulnerable and marginalised members of society, can our nation truly prosper and flourish. And this requires, may I suggest, for its achievement, a diversity of both education and life experience in our judiciary, thus enabling them to garner and develop the widest possible trust among the citizenry. Movicus Levelio, Tronona, may I thank all of you present today for the vital role that you play in ensuring that the courts of justice of our country uphold the rights of our citizens, that our democracy functions at the highest level, and that our courts maintain their integrity and legitimacy, thus ensuring that the rights of all the citizens are protected. Movicus Levelio is Barbanach Tauke. Many thanks and every good wish for the rest of the evening.